Ladies and gentlemen of the Fourth Estate, we are here on behalf of the Federation of Kenya Football, FKF, and in particular on behalf of our client, one Abdullahi Ibrahim. Abdullahi Ibrahim is a National Executive Committee of the FKF. And on the 24th of April 2026 this year, there was a meeting that was convened by some of the members of the said committee. And this meeting's agenda was primarily to suspend the president and the acting secretary and also one of the members of the committee being our client. The reason as to why we have motioned the High Court is because the meeting in itself was an illegality and unprocedural. Article 38 of the Constitution of the FKF dictates that only the president of the FKF can chair these meetings and can call this meeting, and therefore the agenda in itself was an illegality. It should be noted that when this purported meeting happened, no notices were served to our client, nor any notices were served to the president of the FKF. And as such, they proceeded to suspend our client and the president of FKF without any concern, without any due regard to the process of the law. Now, the meeting was supposedly meant to address misappropriation of funds of the tune of 42 million, which some of the members who held that meeting said that those funds were misappropriated. However, the president in his statement was very particular to indicate that the Chan tournament that happened last year, all the payments were directly paid to the supplier and to the insurer and to the insurance. As such, there was no misappropriation of funds. Subsequent to the passing of the resolution that caused the suspension of our client and the president of the FKF, FIFA wrote to the FKF requesting or rather demanding for disclosure of how this resolution was arrived at, in which they gave demands to the effect that should they not respond aptly as to how this resolution to suspend our client was arrived at, that they will proceed to bar us as Kenyans from any competition. That includes AFCON and CHAN. And therefore, as of today, we moved to the High Court with urgent speed and got orders which, in essence, I will read to you. The court noted that pending the inter-parties hearing and determination of the applicant's notice of motion dated the 26th of April 2026, a conservatory order be and is hereby issued restraining the respondents from suspending, removing, or in any other way interfering with the petitioner, applicant's office and position at the Football Kenya Federation and the National Executive Committee or related offices. Further, in the event of any such adverse action or decision has already been taken, the same be and is hereby stayed and the status quo operating immediately before the said action or decision be and is hereby restored by order of this court pending inter-parties hearing and determination of the application dated 26th of April 2026. We have further been directed to serve the application by close of business today, and our firm is serving it as we speak. And as such, we are going to appear before Justice Mwamuye on the 19th of May 2025 for further orders. That is it from me. I will yield the floor to my learned senior, Mr. Danstan Omari.